Good morning. My name is Judge Nardella. I'm joined today on the panel with Judge Edwards and Judge Traver. We're here today in the matter of CB Mother of GW, a child versus DCF, case number 21-2914. Our hearing today is going to be broadcast on YouTube. We're here today based upon an order to appear that was issued to Attorney Alan Campbell. Mr. Campbell, before I give you the opportunity to respond, I want to lay the factual background as this court understands it to be so that you can correct the record if necessary in your response. You filed a notice to appear in this case, a notice of appeal in this case, and thereafter this court, because Florida Rule of Juvenile Procedure 8.517 had not been complied with, issued a juvenile expedite order that required you to file a juvenile expedite certificate. That certificate was not filed, and so on December 8th, 2021, this court issued an order to show cause that asked you within 5 days to file the certificate, which was required by our November 29th order. 18 days later, you filed the certificate, but it did not have all of the required information. 2 days thereafter, we issued another order telling you that the order to show cause had not been dispensed with and asking that you file the required amended certificate within 10 days. You did not. On January 18th, 2022, we issued an order to show cause, asking you within 5 days to tell us why you had failed to file the amended certificate. We let you know that an acceptable response to the order would be filing the amended certificate. There was no response received to the January 18th, 2022 order. Therefore, on February 2nd, 2022, we issued the order for which we are here today, the order to appear. Can you please respond, Mr. Campbell? Let us know if there's anything that you dispute in that factual scenario, and please explain to this court why you should not be sanctioned for your failures to respond.
The only thing that I'm aware of, or that you said that I take deference with, is the January 18th order from the court, because I reviewed what I had received and I didn't see the order from the 18th. I don't know if I got it and it was misplaced, but I didn't see the order dated the 18th that you spoke of. The others are factually correct because I received the orders you spoke of. I did file what I could file because you asked me to file, or the order actually requires that I file the certificate. I filed what I was able to file because after doing the notice of appeal, I did the designation, the directions. I did a motion to find my client indigent and to appoint appeal attorney, which was entered because I had sent a proposed order. I also did a motion in the lower court for her to be found indigent and to have the transcripts that were necessary for the appeal done. I also submitted a proposed order. The court did not enter that proposed order. In the process of figuring out why the proposed order was not entered and being able to fulfill the requirements of the certificate, which without the court entering the order for the transcription to be done, I couldn't respond to some of what was expected to be produced, which was who the court reporter that was doing the transcription was, as well as the order or the paperwork that goes to them requiring them to do certain things as well.
Mr. Campbell, can I stop you there for 1 second?
Yes.
So it's your representation today that you didn't receive the January 18th, 2022 order from this court. Is that correct?
I reviewed the orders that I had saved in connection with this case, and I did not see the 18th order that she spoke of. I apologize if it was sent and that I misplaced it in some fashion because I was not able to locate it to review before today, Your Honor.
I understand. Out of curiosity, you filed a February 6th, 2022 acknowledgement and motion for extension of time, correct?
Yes, ma'am.
That was not in response to the February 2nd, 2022 order?
That was in response to what you had sent saying that I was not in compliance in an effort to explain what the situation was. And also to, based on that, request an extension of time in order to be able to come into compliance, Your Honor.
No, I understand, but our February 2nd, 2022 order references this court's January 18th, 2022 order. So out of curiosity, why did you not include that in your response, that you hadn't received the January 18th, 2022 order that's referenced in our February 2nd, 2022 order asking you to appear today?
I remember, I think the attorney that was appointed on the appeal had filed a pleading, and his plea, there was something in his pleading in the case that spoke of a January 18th order. That's why I didn't address it. Because as I had said in my response, the last one that the court received that you had just spoken of, I had indicated that when I was trying to get what was needed to finish the certificate and move the case forward, which would be, in my opinion, at that time, have the transcripts done and have them attached to the record so it could go up to your court from the lower court to move the appeal forward, that I had spoken to him about why I believed that the order to prepare the transcripts had not been entered, and actually had asked him to rectify the situation as he was representing my client from the lower court now in the appeal. And the reason that I asked him to do that rather than do it myself is I now have a conflict in this case. I work for the Department of Children and Families, and that she is appealing against the Department of Children and Families. So it puts me in a position where my current employment creates a conflict for me. So I had asked him, explaining what I perceived to be the issue, and had asked him to address it.
Mr. Campbell, if our clerk's records indicate that the January 18th order was received by email and acknowledged by email at your office, you don't have any reason to dispute that, do you?
No, I don't, Your Honor.
And why, when the January 3 order is directed to trial counsel, which had to be you, the November 29th order was directed to you, why did it take so long when you had 5 days to respond? You took several weeks to respond. Why was that?
Because unfortunately, Your Honor, and the reason that I'm now working for the Department of Children and Families and no longer maintaining my private practice, Your Honor, is that during that time frame, I was diagnosed with cancer. It was described as a fairly aggressive cancer. And because of that, I had to go under surgery fairly quickly. The earliest date that was able to be secured to do that was the 8th of December. So it was shortly after the November order that I was operated on for the cancer. And I was I was not working for close to a month, Your Honor. I was doing minimal work during that time. But at the same time, I was concluding my private practice. And in order to do that, I was entering, because most of what I was doing was court appointed in several counties, court appointed dependency, delinquency, and criminal cases. And I was doing orders or proposed orders and motions to withdraw in those cases, Your Honor. I had initially not done one in this case in the lower court because I had thought that I was able to have done enough that it wasn't necessary to appoint somebody to replace me in the lower court. On hindsight, and given what has transpired in the history of this case, I probably should have done a motion to withdraw in an order and had somebody appointed to finish out anything that needed to be done in the lower court level on this matter as well, Your Honor. And for that, I apologize.
Understand that the whole idea behind TPR appeals is that they're expedited because children need finality one way or the other.
Yes, sir.
And, I certainly understand what you're saying. And we're treating all our conversations with you as if you were under oath, which I assume you agree with without having to raise your right hand, correct?
Yes, Your Honor.
All right. And the information that you shared with us about your health condition is certainly an understandable reason why you couldn't give a formal response, but a brief response that you were ill and needed an extension of time would have been appreciated and would have avoided an awful lot of misunderstandings, especially if the appellate counsel was aware of that, but there's nothing in the appellate counsel's response, which he finally filed, that indicates he knew that you were out of commission.
I understand what you're saying. As I said, my apologies. Court, it was not my intent to belabor this matter. As I said, given the situation and most of the cases that I was carrying, I did motions to withdraw and proposed orders and resolve my involvement at a time in that way. I probably should have done likewise here. I felt that it was close enough to finality that it wasn't necessary, but in hindsight, I feel like it would have been more appropriate. And I apologize, as I said before, to the court for that.
When did you become aware that the transcript was actually filed?
I was aware that it was actually filed based on the response to the last response that I made, the one I think that was February 9th, when I responded to the February 2nd order from the district court. That's when because the extension and I requested an order to make arrangements to get, because I did provide another proposed order to the court and see if I could get the transcripts done. And then the response from you all indicated that they had already been received with the record on appeal, and based on that the extension of time was not necessary.
Fair enough. So inferentially, I can assume that you weren't discussing anything with Mr. Cartelli at that particular point in time, and that the only way you learned that effectively the juvenile expedite certificate had been mooted was because the transcript had already been filed when we told you about that on the 8th.
Yes, sir. That is correct.
I think part of the challenge that I'm having personally, Mr. Campbell, is the notion that any of our orders, much less repetitive orders, are optional. And I don't necessarily know if I'm hearing in your response an appropriate appreciation that our orders directing somebody to do something in one of our cases is every bit as important as any one of your other cases, health issues aside. And I agree with Judge Edwards. If you'd have let us know about this in any way, and I respect that might be your business and that you might not have wanted to let us know about it, and that's fine too. But we're always amenable to hearing a justifiable reason why you're unable to respond to our orders right away. It's the ignoring it that has you here today. And I was just wondering if you would react to that and let me know that you appreciate that in some way.
I do very much, Your Honor. It was not my intention to be here in this way, as well as to force you all to be in the position you're in. I realize that. It was not my intent to avoid the order. My intent was to resolve the matter, and I didn't have anything, as you'd asked. I think the order was that what I had sent you in response to the request for the certificate was incomplete, was what I had received. I was trying to resolve that issue as quickly as possible with the thought that by resolving it, and then I would be able to supplement what I had previously supplied to you all. I had nothing further to supply because the proposed order I had sent through had not been entered. I had taken the opportunity to inquire from the court, the lower court, why it was not entered, and was trying to take steps to rectify that. And perhaps that was not the most expeditious way of doing it, that I should have directly addressed you all, but I felt like I had nothing to provide you all other than to say I thought I had done what I could do and that it had so far been unsuccessful. But I do appreciate the necessity of responding to you all.
Thank you.
And for that, I would apologize as well, sir.
Are there any other questions in the panel?
Oh, anything else you'd like to add, Mr. Campbell?
Your Honor, I'm sorry, or all of your honors, I'm sorry that this matter came to the situation. It was certainly not my intent. I have great respect for the court. I have appeared before it in the past, and I did not wish that this was, how things would go. I apologize for not having handled the matter more efficiently and effectively, and I certainly, as I said, do respect the court, your honors.
Thank you, Mr. Campbell. We are adjourned.